We appreciate that you're taking the time out of your day today to join us, and we hope you enjoy our program. My name's Carol Anderson. I'm the marketing director here at Generations Law Group, and I'll be the moderator for the event. And today we're talking about protecting your assets if you or a loved one may need nursing home care. Our presenter is our Associate Attorney, Samantha Gentle. Sam is our mass health planning and applications expert and helps many of our clients with their long-term care planning. So Sam, thank you for joining us today as well. And I'm going to turn it over to you.
Hi, everybody. Thank you for joining us today. So we're going to talk about how not to go broke in a nursing home. So generally speaking, the cost of nursing home care at this point is about $500 a day or $15,000 a month. But there's a lot of advanced planning you can do to help reduce costs and protect assets. So one thing you can do earlier in life is get long-term care insurance. It can be costly, but the younger you do it, the cheaper it's going to be. So, probably your 40s and 50s is the best time to do it. There's different kinds of policies. The traditional long-term care insurance with proper minimum coverage can help prevent a lien being placed on your home as a result of needing mass health for nursing home care. It may give you some freedom to do more with your property than putting property in an irrevocable trust, which I will talk about later. The caveat to this that's important to note is that when you have long-term care insurance, in order to avoid that mass health lien, your policy needs to still be in effect when you're at the nursing home. Because, I think most of us will say, well, I want to stay at home as long as possible. And long-term care insurance can be used for home care as well, or at least most policies. It's good. If you have it, you may want to double check. But theoretically, you might want to try to use it up all at home before needing nursing home care. But if you're trying to protect your home, you may need to move to a nursing home before the policy runs out, even if it's like, you'd have to look into it a little bit deeper about like how long, maybe a month or something like that. There is also a new kind of hybrid life insurance, long-term care insurance policy that's becoming popular now. The benefit of it is, you pay into this policy, and with traditional long-term care, you pay into it every month or whatever for a very long time. And if you don't use it, you lose it. With this kind of policy, you pay into it, you can draw on it to pay for long-term care. But then if you don't use it up, then the remainder of the funds gets inherited like life insurance. This type of policy won't protect against a mass health lien, at least as the regulations stand now. And one of the reasons for that is that if the policy has a cash value, it will count towards your asset limit. If it has a cash value, that means like you could close the policy and get money out of it, then that would, cause you to be ineligible for mass health. But I think there's some attorneys that are into regulating and are trying to figure this out as we speak. So how estate planning can help. Having documents ahead of time is extremely important, particularly a healthcare proxy and durable power of attorney. When you don't have these documents in place, if you lose the ability to make decisions for yourself, if there's no healthcare proxy in place, that's for healthcare decisions, you'd need a guardian, which you'd have to get through the probate and family court. And if you don't have a durable power of attorney, then you need a conservatorship through the probate and family court. These proceedings are very costly with legal fees and very time consuming. Takes a long time to get a hearing. So having these documents ahead of time makes it much easier for your loved ones to be able to primarily take care of you, and then also gives them the freedom to do any of the potential last minute asset protection planning that I'll talk about later in the presentation as well, in addition to just helping you pay your bills, all that kind of stuff. One way to protect your home is to do an irrevocable trust more than 5 years before needing nursing home care. Irrevocable trusts only work in certain circumstances, like you need to not have a mortgage on your home. So your mortgage needs to be paid off in most circumstances. And you need to have enough cash outside of the trust to be able to support yourself. If you accessing the value of your home is part of your retirement plan, then an irrevocable trust is not the right sort of thing for you, which is fine. And again, you need to make it more than 5 years before needing nursing home care if you're planning to apply for Mass Health to pay for that care. Some people may have extra financial resources as well, so you can put cash in the trust as well as a house. Another thing that we can do for married couples is called a will with a testamentary supplemental needs trust. Normally with estate planning, we try to avoid probate, which means, if you have an individually owned asset, before it can be inherited, if it's not in a trust and there's no beneficiaries, has to go through probate. But when we're doing Mass Health planning for married couples, it actually makes sense to have some assets go through probate. So this type of will have a trust inside it for your surviving spouse. And a trust can get set up for them after your estate is probated. The money can be there for your surviving spouse's supplemental needs while they're alive. If they're on Mass Health can't touch the money. And then once they pass away, then the kids or whoever you've listed as your beneficiaries can inherit from you at that time. So we were just talking about estate advanced planning techniques. Now these are the last minute measures, and with the big asterisks that please do not attempt these on your own without the advice of an elder law attorney. So something that we always recommend is a prepaid irrevocable funeral contract. A lot of this topic is morbid, but I feel like that goes to another level of me being morbid. And so some people are not comfortable with doing these, but everyone's going to need a funeral at some point or some kind of service. I mean, some people don't want one, but if that's something that you would like to have, you can go to a funeral home and you can get a prepaid irrevocable funeral contract. And for whatever silly reason, Mass Health does not want you to prepay for flowers or food. Most funeral homes in the area are kind of aware of the Mass Health rules. So even if you did do this without talking to an attorney, but let them know that you're doing this for Mass Health planning purposes, most likely they'll know what they're doing. And then when you pay for these contracts, I believe they're sort of protected, kind of like when you pay your attorney and it goes into a client funds account. There's a way that your money is protected as well for these funeral contracts. Another last minute spend down is a burial account. So each spouse, if they're spouses or if it's just one, then you get one account for an individual, can have a burial account with $1,500 in it. There's a special way it needs to be set up, but then Mass Health does not count that as an asset for that individual. And then just to add to Mass Health's silly rules, like I said, with the funeral contract, you can't pay for flowers or food, but with the burial account, Mass Health doesn't really track what you do with that money after the person dies. So theoretically, you could use that for flowers and food.
Sam, we have a couple of questions if
Oh,
you
sure.
can take one. So the
Yep.
first question is, my husband and I divorced. His estate was done before our divorce, but he wants to leave everything the same. Are these documents still valid because I am by name not wife?
Yeah, he needs to update his estate plan.
Okay.
And that usually, I thought divorce attorneys usually encourage that as part of the divorce agreement.
Okay.
So he should definitely check on that.
Even if he still wants to leave everything to her?
Yeah, because if I remember correctly, there's something may have gotten invalidated by the divorce, so even if he wants to keep everything the same, he
Mhm.
still should get it updated
Okay.
post-divorce.
Okay. And then the other question is, what does irrevocable mean for burial? Someone has paid up front.
For the for irrevocable funeral contract, that just means after you've paid for it, you can't get your money back.
Is there a limit how much you can spend on an irrevocable funeral contract? Can you have both a burial account and an irrevocable funeral contract?
You can absolutely have both the funeral contract and then the $1,500 burial account. I don't know that, I haven't come across a funeral contract that Mass Health has rejected. I think maybe if it was, a very elaborate, outlandish funeral, they might question it, but I mean, I've seen them be like 15,000 or something, so
Okay.
hopefully, so I don't totally know the answer to that question, but usually if someone's working within the regulations, it's fine, and then if something seems a little outlandish, maybe they'll raise an eyebrow.
Okay.
So, but that's a good reason to check in with the attorney before you do that.
Mm. And if one has quite a bit of money, but does not want it to go to nursing home, how much can you gift to your children beforehand without getting in trouble? Are we going to get to that?
I will be getting to that.
Okay. All right. Continue on, Sam. Thank you.
Okay, so here's some other last minute asset protection measures. This is for married couples. So there's no penalty to transfer money, if one spouse is going to the nursing home or needing home care. You can transfer all the money and the real estate to the community spouse, which is the spouse healthy at home. Once all of the assets are transferred over, if that community spouse ends up having more than their asset limit of $148,640, that's the asset limit for 2023, then they can get a Medicaid annuity. The value of the real estate does not count towards that asset limit unless you have two pieces of real estate. And if you have one piece of real estate, as long as your home equity is under, I think now it's a little over $1 million. So as long as it's under $1 million in equity, then that should work. If you're over $1 million, then sometimes we can figure out a way, like take out a home equity line and reduce the equity. When it's a single individual, the best tool we had was a pooled disability trust. The way that works is it's a supplemental needs trust, and it's managed by a trust company. There are two main companies in Massachusetts that handle these trusts. One is Plan of Massachusetts and Rhode Island, and the other is Guardian Community Trust. Our office tends to work with Plan, but I've worked with Guardian as well, and both are fine. The money can be in the trust for that person's supplemental needs while they're alive, and Mass Health can't touch the money while they're alive. Now, when the person passes away, the trust company gets a certain percent for their administrative purposes. Then Mass Health gets a crack at it, and they want to try to get paid back for what they spent on that person's care. If there's still money left over after that, then the money can be inherited by the beneficiaries they chose when they set up the trust. But unfortunately, there's been some back and forth with regulations, and originally the cutoff date for funding these trusts over the age of 65 was actually going to be this June of this year. We've now been able to get it extended till spring of 2024. But we hope that with the elder law bar, NALA, that we're able to argue that it should go back to the way it was. I've done a pooled trust for someone in their 90s before, so hopefully we get it back there, but it's still available until next year. Another last minute spend down is the caretaker child transfer of a house. This is a wonderful way to protect a home if you have the right situation. So your child will have needed to live in your home for more than 2 years. It needs to be that child's primary residence, so they can't have an apartment, but then also come and take care of you. Needs to be their permanent address. And then if they're assisting you with activities of daily living, and if the care they provided prevented the elder from needing to go to a nursing home sooner, then we can actually transfer the whole house to that child and protect it in full. So I've done that a number of times. It's a wonderful thing that we can do to protect a home. But needs to be a lot of paper documentation showing that the child actually did provide the care, proof that they lived there for 2 years. Unfortunately, it doesn't apply to grandchildren. It does not apply to nieces and nephews.
And then someone's asking, we have a revocable trust. Would we be eligible to set up a single premium immediate annuity if one of us needs to go into a nursing home?
Yes. And just that, if you have financial resources in that revocable trust, then they just need to be moved out of the trust to, may need to close some accounts or draw money out of it to move the money to the annuity.
Okay. And on the same line, if you have a long-term care insurance, can you set up a single premium immediate annuity?
Yes. Yeah, it's separate.
All right. Thank you.
Good questions. Another last minute asset protection measure. If you have a disabled child, you can actually transfer unlimited amounts of money to them. But you need to do this carefully, particularly if your disabled child has any public benefits or may have public benefits in the future. So it depends on what sort of benefits they're on and whether or not they've been determined to be disabled by Social Security. You may consider setting up a third-party supplemental needs trust for that child. I have had some situations where it's clear the child's disabled, but they've never applied for any benefits because they've been unable to do that. And some circumstances, if we were trying to get proof that a child's disabled, Mass Health has their own disability determination unit, and you can try to submit documentation about that child to see if they can determine that they're disabled. Will Mass Health be needed? So here are some additional Mass Health rules. So for 2023, if you want Mass Health home care, I didn't change the 2023 on the second line. I meant to do that. So the 2023 income limit is $2,742. If you are over income, you can still receive Mass Health home care, or also known as the Frail Elder Waiver. However, you may need to pay a large deductible every 6 months. But it's a common misconception that if you're over income, you can't get it. A lot of people get confused about that. And what makes it even more confusing, if you apply and you get approved with a deductible, the approval letter comes through and it looks like a denial letter, just to make everything more confusing for everyone. For asset limit for an individual is $2,000. So it's okay if when you receive your income in the middle of the month, it's okay if your account goes over 2,000, just as long as it's back under when at the end of the month. So it has to be under 2,000 at the end of each month, and also on the day you apply for Mass Health. A married couple asset limit, if they're both applying for Mass Health, is $3,000. Mentioned before, the spousal asset limit, if for either home care, nursing home care, community spouse, asset limit is $148,620. And then the maximum home equity is $1,033,000. So Mass Health has a 5-year look back period. So this, I'm starting to get into gifting and stuff, which will go back to that other person's question. So Mass Health has a right to look at your accounts and look at every transaction for the last 5 years of $1,000 or more. That also includes transfers of real estate and cars. I've had people not realize recently that, you know, transferring to a car or grandkid, that's a gift too. So we want to avoid making any of these mistakes 5 years before needing nursing home care, which obviously is tricky because you don't know when you might need nursing home care. So there are some ways to give gifts, but we need to be careful. So a common mistake, giving money to family members and friends less than 5 years before needing nursing home care. A common mistake I see a lot is, oh, my accountant told me I can give $17,000 a year. So that's okay for tax purposes. That is not okay for Mass Health. And then also, it's better to be using like a debit card or write checks or use a credit card instead of withdrawing a lot of cash. Sometimes we can explain it away, like this is just how they regularly paid their bills, etc. But if you're withdrawing like large sums of cash, then Mass Health is going to want record of, you know, what that money was used for, because they may think that you're gifting money to someone. Having multiple accounts at multiple banks, it can be an issue, because sometimes when you, I have had many clients that have had, you know, many CDs, opened accounts at 5 different banks. But when you do that, there's a chance that you're going to forget about an account. And if that account that's laying out there is causing you to be over the asset limit, you know, that could put your application in jeopardy. So I recommend, you know, consolidating your accounts if you can. Like keep it under 20, please, if you can. And also paying a caretaker under the table. That's another common one. We can help with that if you do have a caretaker you want to pay. It's better to, you know, and it's a common mistake. You think this person's coming to my home, they're super nice, they're helping take care of me, I want to pay them for their service. And that, of course, you should, but it's recommended that you set up a care contract with them and that you pay them through a payroll company. And that's something an elder law firm can help with. Other common mistakes are transferring real estate, car, or an asset of any value to a family member without having them pay fair market value, transferring real estate to a family member and retaining a life estate. That is okay in a lot of circumstances, as long as it's done more than 5 years before needing nursing home care. But we tend to try to encourage our clients not to go with the life estate route, because basically when you transfer a deed to a family member and retain a life estate, that means, you know, it's still your home, you have the right to live in it, and you're responsible for house bills. However, if the family member you transferred your house to gets sued or gets divorced, that's considered an asset of theirs, and your home could be at risk. So if it's that sort of scenario, that's when we try to encourage the client to do an irrevocable trust instead of doing the life estate deed. And then certainly not having a power of attorney or having a power of attorney, but not knowing the location of the original can cause issues as well. And I guess I'm already at the end of my presentation. I didn't even realize it. Thank you for listening. And does anybody have any further questions?
There is a question. When a loved one is entering nursing care, is it too late to take action to protect savings? What steps should be taken? This was someone who joined late.
If you want to, I mean, certainly watch the link that gets sent out. It depends greatly on that person's situation. If they have a disabled child, we can transfer money to them. If it's a married person, we can transfer money to their spouse. If it's a single individual, we can potentially do a pooled trust, but I go into all those details in the slides.
Great. Are there any other questions?
Well, I have a question.
Oh,
This
go
is Howard.
ahead. Hi, Howard.
So the way I have my wife and I are a second marriage. The way I have it set up is, everything is in a trust. And it's set up that she can remain in the house as long as she wants. And then, the beneficiaries are my children. Is there any problems with that?
Well, not necessarily, but if your home's in a revocable trust, then it's not protected against a mass health lien. So.
Okay.
So I think if you want to explore mass health planning, that's worth another conversation with your attorney.
Okay, and I know Tris has her hand raised. So Tris, when you're ready.
Sorry, I don't have my camera on. I guess I'm already divorced, but I'm curious, is this why some couples, when they're facing a difficult situation, actually get a divorce? Is that a legitimate thing to do to avoid a lot of this happening from one spouse losing everything toward the nursing home and qualifying some for Medicare?
Medicaid is mass
Medicaid,
health.
I'm sorry, Medicaid.
That's okay. Just everyone mixes those up. So I always like to make sure to correct. So I feel like in the past, getting a divorce was more common with mass health planning, but because you have the opportunity to transfer all of the money to the community spouse, then that's an opportunity to protect assets. Where if you've gotten divorced, and I don't know, it would depend on the type of divorce, because if everything gets split 50-50, then the person entering the nursing home or needing mass health home care, their option is really just the pooled trust, which isn't, the best option, because mass health can still get it in the end. It's just if there's money left over after mass health gets paid back, that they can, the kids or whoever could inherit.
So there's a couple of questions here. Our long-term care premiums keep increasing. We keep choosing to pay the higher premium. Is there a way for someone to tell us if that is necessary, or can we select the options they offer to reduce the premium?
I would speak with either your insurance agent, or if you need one, we can give you some names, because I wouldn't know the answer to that question, and I wouldn't want to say the wrong thing.
Right. Malka had a comment. If you want any choice in choosing a nursing home, you should have some assets. Even though it is illegal, nursing homes do discriminate against people who enter on mass health only.
Yeah,
so
agreed.
Malka is a care manager, and so she deals with that a lot.
Yeah, unfortunately, usually what I recommend when I'm working with clients on the final spend down to prepare for mass health, I try to recommend it so they can get their foot in the door, to, if we can, to have 1 to 2 months of private pay money available before we switch over to mass health. I have done applications successfully where someone enters the nursing home, quote unquote, mass health pending, which means they're under 2,000 when they enter. Those nursing homes are harder to find, but they are there. But you're going to have a little bit less, just a little bit less options. And then also usually they'll require that I've basically fully filled out the application before the person moves in, when normally I don't have to do that. So that's sort of the extra hoops. There's a question about reverse mortgages.
Mhm.
So a reverse mortgage is a good option if you want to access the value of your home to help pay for care while you're at home. It will, again, if you want a reverse mortgage, then you will not have been able to use an irrevocable trust as a planning tactic, because like I said in the beginning, with the irrevocable trust, you won't be able to access the value of your home at that point. Why do nursing homes discriminate? Because they get paid more when people pay. The private pay rate is much more than what they get reimbursed from Mass Health. I will say though that I think if you hire an elder law attorney to work with you, as opposed to trying to do it yourself, which I don't recommend, you may have better luck getting someone in the door Mass Health pending, because then at least they'll have the confidence that if you are working with an elder law attorney, that they know what they're doing, and they may be more willing to make an exception, but still it will be difficult.
And I hope you all have a great afternoon.
Thank you very much.